Hello. Today, we're going to the Miami-Dade Courthouse in Miami, Florida, to the courtroom of Judge Laura Shearon Cruz for Courtney Clenney status conference. From what the agenda is listed as, they're going to be discussing confidential documents that previously have been received by the prosecution under judge's order when they attempted prosecution of Courtney Clenney's parents for the laptop, and those charges were dropped. But basically, they're in possession or have seen certain documents that the defense are saying are attorney-client privilege and that they can't use at all. The hook in it is we're going to hear that the Miami Herald is actually motioning on this, that if the judge does dismiss the case because of this information being used in the case and seen by the prosecution, that they want it publicized because it would be the reason for dismissal. Anyway, we're going to listen in. Let's get started.
Versus Courtney Clenney. If everybody wants to announce their presences for the record.
Khalil Quinn and Kathleen Hogue for the state of Florida.
Sabrina Puglisi, Frank Prieto, and Diane Cronus for the defense.
Okay. And then good afternoon. And then I have the motion to intervene from the Miami Herald. Okay. All right. So we had before us what defense had titled as the unopposed motion to determine the confidentiality of the court records and the state's memo of on regards to that motion. So we're here right now for that. It does relate to the motion to depose Mr. Khalil Quinnan. But right now the motion for intervention is what I think that we need to address before we go forward with that motion to depose. Thank you. And so we rescheduled this so that we could hear from everybody, including the Miami Herald, about that request. I did read through everybody's, well, obviously the original motions, the Miami Herald's motion to intervene, and then the responses to the Miami Herald's motions to intervene, which I think were filed by both parties this week. So let me hear from the state and defense, both about the initial motion without referencing anything that's not already on the court record about what you're asking to be confidential. I think at the last setting, we almost went into some of those facts. We're not going to do that today. And then I'll hear from all of you I'll hear from the Herald about the motion to intervene, and then the state and defense about their responses to that.
Do you want me to start, Judge, since it's my motion?
Oh, yes, I'm sorry. It is your.
No, that's all right.
motion. Yep.
So Judge, I don't know if you need me to, it's laid out in the pleadings, Florida Rule Judicial Administration 2.420, kind of the process on how that works as far as subsection F in criminal cases, which takes you to a few other subsections, but really it is C9A1, little I, Roman numeral I, that says that records are exempt if it prevents a serious and imminent threat of fair, impartial, and orderly administration. So that's kind of where we start in the rule, and then we move on. You received the document in question, and I think the first thing to say is that document was drafted specifically for litigation purposes. I think that's clear. I also think, I know one of the arguments the prosecutor made is nothing within the document has not already been publicly stated by either of both defense counsel, had not already been made public through discovery, or will not inevitably become public. What is inevitable to become public is not something that should matter to the court, because the defense in a case does not need to be laid out and until and unless the defense is ready to do that. Could be motions in limine that the court puts in an order as far as when that's due. It could be, for example, just generally speaking, if a defendant were going to testify at a trial, the court doesn't get to know that. The defense doesn't have to say anything. The prosecution doesn't get to know that unless the defense announces it, or right before it's that portion of the trial, the judge asks that of the defendant. So I think we can generally speak about the document without going into the specifics of it. Just like anything, it's obvious any defense lawyer is going to do investigation and do research, legal research and try to find witnesses. Those are generalities, which we can talk about without getting into the actual specifics about what that is in the document. And I think that is what the rule requires for the judicial rule of administration. It says you must be able to specify and identify it and with specificity, but without going into the reason why it's privileged. So I guess the real question here is this document privileged? It's attorney, client, and work product. We believe it's both. And the standard is different with respect to both. And so I think the first thing the court needs to do is, one, determine if the document, is attorney-client and or work product privilege. Two, if the court does believe it is one of either of those, whether it was waived when the defense disclosed it to a third party that was not Ms. Courtney Clenney. And three, even if the court believes it is one, not privileged, or two, yes, privileged, but was waived, should that still be kept confidential and sealed? And I think this is the only part, and I'm not going to speak for Mr. Ponce, but I think that's where we kind of differ, which is even if the court doesn't believe this is a privileged document or believes we waived it, it still should be kept confidential because it's information that should not be disclosed to the public. So that's kind of where we're at. And I'm happy to go into each of those. I did brief them, but I can speak briefly as to each of the privileges first and why we didn't waive it.
Give me your bullet points on the attorney-client privilege, and then we'll go into work product. Yes.
Okay. So with respect to attorney-client, if you look at 9502C1 and 2, specifically, a communication is confidential if it is not intended for third parties except one, those to whom disclosure is in furtherance of the rendition of legal services, and two, those reasonably necessary for the transmission of the communication. So the question here is, what is in furtherance of the rendition of legal services? We know that the Clenneys, Mr. and Mrs. Clenney, the parents, are paying the legal fees. That came out in the Arthur hearing. Mr. Clenney testified and he talked about it. So the fact is, and this really applies to any case where family members are paying for the fees of their loved one, defense attorneys do speak to them because they need to discuss. Can you imagine what the ramifications would be if I just went to a client and I said, for example, give me $50,000, and I'm just throwing a crazy number out. Give me $50,000. I'm not going to tell you what I'm going to do. I can't tell you anything about the case. I can't tell you any experts, any investigation, any motion. I'm not going to do anything. That's just not practical. And that's why the court specifically in this rule, actually, that's why it specifically allows for attorneys to be able to discuss if it's in the furtherance of rendering the legal services. And if you look to the case that we cited, Gerheiser versus Stevens, that's Gerheiser versus Stevens, Stephen's. That's a 4th district case from 1998. And there's really not a lot of cases on this, Judge. So really this 4th district case, it was a mother who communicated with the lawyer about hiring or retaining them for her son. The question was whether that communication was privileged. And the court said that, yes, it is privileged because it is in furtherance of rendering legal services. The state cited State versus Black, where it was not considered privilege. And that was a jail phone call between a defendant whose sister made a three-way call to the attorney. And what the court said is, no, this is not like the case of Gerheiser. This is different because one, it says the call is going to be recorded as you're making the call. So that should have been known. And two, in that case, the attorney didn't explain why, that person's needed to be on the call. So it can be distinguished. As far as, and just to be clear, Judge, we were communicating what needs to be done in the case because they need to understand in order to be able to be prepared for the costs that will be involved and to justify the fees that were being charged. So I think this clearly falls within a communication that would be under attorney-client. Now, with respect to work product is actually even, it's even broader. And the court knows about this because in the last hearing we had, you even in the order, you distinguished between opinion and fact work product. The case of State versus Rabin is very good at kind of laying that out. And actually the state cited a case that it doesn't really apply. It was in the corporate context for attorney-client privilege, but it gives a great analysis of work product privilege. And that is Burrow versus Forjas Taurus, Burrow. Forjas is Forjas, Taurus, Taurus. It's a Southern District of Florida case from 2018. I have a copy for the court if you would like. And really, if you go to page 2, Judge Torres does a really great job at setting forth an analysis on work product. He talks about the difference between opinion work product and fact work product. And what he says on page 2 in the first paragraph dealing with the work product doctrine, he says, and this is on 1227 page, because the work product privilege looks to the vitality of the adversary system rather than simply seeking to preserve confidentiality, it is not automatically waived by the disclosure to a third party. It requires the party asserting protection under the work product doctrine to demonstrate that the drafting entity anticipated litigation at the time of the documents were drafted. I mean, clearly this is the roadmap, what we're going to do to prepare for trial. So I don't think there's any question it was drafted in anticipation of litigation. And because this is about what it is, the logic behind it, the rationale of work product is that your adversary doesn't see your mental impressions. And that's what opinion work product is. It's the mental impressions of the attorney. Clearly, these are the mental impressions of myself and my team. And so the question really is, was it disclosed in a way that your adversary would reasonably get access, that I would reasonably know my adversary is going to get access to the document? And the question then would become is, okay, I sent this email to the Clenneys. Would I have known that Mr. Quinnen or any of the prosecutors in the case would have been able to get access to the case? I would have to assume that and have knowledge or evidence that they got an iCloud warrant for them. I couldn't know that in the case. The parents are not part of the facts in this charge, and there would be no reason for me to know that. And let's assume that even I was afraid that somebody could look at it. This is why I titled it privileged. I titled the document checklist of things to do - privileged. And I agree with Mr. Quinnen, just calling something privileged does not necessarily make it so, but this clearly is a privileged document when it's my mental impressions. It's work product, I claim it as work product, and I wrote that it was privileged. So the question becomes then about waiver. And just to go back in that case, on page 4, it says opinion work product enjoys a nearly absolute immunity. It is much more stringent than attorney-client privilege, which I still believe belongs here, but it is very hard to waive opinion work product privilege. And so then we have to ask ourselves, did that happen in this case? And In the work product aspect of it, Judge, no, I couldn't have known. I did everything to protect that document from being disclosed to people other than who was on that email. And the prosecutor stating that we have disclosed some of what's on it or will inevitably be disclosed, it doesn't matter. If a document is privileged, it's privileged from when it was and forever privileged. And so whether it's a roadmap of my case, whether I've already filed a defense witness list with some of the witnesses, whether I filed some motions, I can tell you that at least 9 points in there have not been disclosed to this court, to the media, to the prosecution, to the public. And whether the defense inevitably decides to put that out for trial, I don't even know yet because we haven't even set a trial date. We're still preparing. We're still investigating. There's a lot that goes into it. So I don't even know at this point, but there clearly could not have been any kind of waiver. Let me just see if there's anything else with respect to the waiver, Judge. And I don't know if you have any specific questions about what I've said so far.
I don't.
And I would probably wait to go into the third point, which is even absent those things, unless you want me to, but
Well,
even,
we can wait and see whether or not, I agree with the Herald
Right.
that it's.
because I don't think
going
we
to
get,
Decide one
Okay.
or decide the other.
I don't think we get to 3. So, okay.
All right, so let me hear from you, Mr. Quinnan, about those points about the privilege first, and then we'll get to, the sealing and the confidentiality.
Yes, Judge. I think I would like to begin with Ms. Puglisi's argument that even if it might have been waived in some respect, the document, because it's quote opinion work product, maintains its privileged nature, even if she went on TV and literally said the 20 items on that. And I think that's incorrect. Just as a premise, if we proceed to trial, Ms. Clenney's convicted and she attacks her representation as ineffective, that privilege is waived. We get a copy of the file, we review a copy of the file, as common within a Rule 3 litigation. I think it's actually explicit in the rule and the doctrine about the waivers of privilege that come with that. So that's not correct. We have to read all of these rules together with one another. And so, as Ms. Puglisi correctly cited into 9502, it has to be in furtherance of the representation. So was this email communicated to the parents first as their other clients as witnesses? Yes or no? I think it's unequivocal no. That wasn't, this is what we're doing to prepare you as witnesses. It's, this is what we're doing on Courtney's case. So it was unequivocally uninvolved to Kim and Deborah Clenney's representation by Frank and Sabrina, or excuse me, Ms. Puglisi, Mr. Prieto. My brain just went to your first name. So it's unequivocally uninvolved with that representation. So it's regarding Ms. Clenney's representation. What within that email really discussed, we need, so for example, I'm gonna use Ms. Puglisi's example of money. We need $50,000 to do X. Okay, was that in that email? It was not. Was it, we need you to sign an authorization of, school records from Ms. Clenney so that we can build mitigation? Again, hypothetical situation. That's not what was there. That was, we want you to know what we are doing. Email. And that is a voluntary, that is a textbook voluntary disclosure to a third party, period, bar none. There was no request for work. There was no request for assistance. And the Gerheiser case that we cited to, that I appreciate Ms. Puglisi mentioning, and in the original privilege litigation, we also cited to a case called Witt versus Witt, and I can get that cite for the court, where there are circumstances where family members can be agents. So in Gerheiser, that was a juvenile who was in custody and could not retain his own counsel. So his mother went to retain counsel. And what was privileged in that discussion was the discussions with the lawyer about the son's case, period, in terms of retaining that lawyer. That's not what we have here. Again, Mr. Prieto and Ms. Puglisi, as we argued in that proceeding, were already retained by Ms. Clenney. They had every means of going to go see her at the jail and talk to her at the jail and explain what they need and why they need it. And as it pertains to her parents, if there's any kind of bill, for example, Ms. Clenney has frequent calls with her parents. She could say, Dad, I spoke with my lawyers and they need the $50,000 for the thing that they're doing. That's perfectly fine. That's perfectly protected. But the problem here is that that's not what existed in this email. That's not what occurred. Besides that, I don't entirely agree that it's opinion work product. At the end of the day, it's just a fact work product of, you know, we have to do X, we have to do Y, we have to do Z. It's not, I think that this is going to be a problem, or I think this witness is not credible, or what would actually impart impressions there. It's essentially call the witness, schedule the witness, get this, and I'm not quoting anything there. These are all hypotheticals because I have to tiptoe around it. It's a to-do list. It's not a we think this, we think that. So respectfully disagree as to whether it's opinion work product. As it pertained to the instant motions, and again, this is a slight shift from the privilege, because again, our position on the privilege has never changed, including as it pertains to the other litigation. And of course, we respect this court's order on that case, though we disagree as we outlined in our pleadings. This is inherently different in various different respects. Again, explicitly voluntary disclosure, but beyond the voluntary disclosure is the remedy. Well, I guess I'm getting into the other argument, so let me back off of that. The state's position as it pertains to the confidentiality was that all of the matters should be confidential because it would necessarily limit our ability to discuss in the response to the deposition motion the document, because that's a good chunk of their position. So all of the proceedings should be confidential. If the state is correct and the court agrees with the state and the court grants our motion or denies the defendant's motion, however that proceeds, then whatever is appropriate to be unsealed would be unsealed. The problem is that candidly, the defendant in their motion to compel and our deadlines in responding to that motion to compel required us to address at least one bullet point in that respect. So it's put us in a position now where, you know, the cat's already out the bag, the bell has been rung. So there's that aspect. And then finally, as Ms. Puglisi mentioned, there's at least 9. I haven't really re-reviewed that document on purpose for this court's reasons and for collateral matters. But if there are 9 things, and I'm assuming it was 20 items on the list, just taking their word for it, 11 of them should not be redacted. So at the end of the day, that's the bottom line law is, as I don't care whether it is or isn't sealed, but that's just the state of the law. So
Judge, with respect to Mr. Quinn doesn't believe that it's work product. So the rules, sorry, yes, opinion work product. The rule states the mental impressions, conclusions, opinions, or legal theories of a party's attorney or other representative concerning the litigation. That does not say and in between there. It says or. The mental impressions. Those bullet points, it does not say it has to be in a paragraph format, how it needs to be put. Those bullet points show, after evaluation and knowledge in the case, things that need to do. Those are mental impressions moving towards litigation. I mean, I don't think it could be more clear than the fact that this is opinion work product. Now, as far as the attorney-client privilege, yes, this is not a communication that involved our representation of the Clenneys as the parents. This had to do with Courtney Clenney and her representation. And it's just not practical what the state attorney is saying, and I don't think this is what the rule says, which is that, yes, we were retained, but that doesn't mean that costs don't still come up throughout the case, that you're not still discussing with the family about the case. And it says here, he says, Mr. Quinnen said, it's what you want you to know what we are doing. Yes, how is that not disclosure in furtherance of the rendition of legal services? That's exactly right. What he said, it falls exactly under that definition. And so it's just, defensive attorneys don't do that. They don't talk to their clients about the fees when she has no access to the money. So you're talking to the people who have access to the money and pay it, and you're talking to them about what you're doing. And this is just very common communication. And as far as even if we've disclosed some, because that's part of our case, we've done it through filing defense witness lists. That doesn't mean that, okay, you can unseal or disclose part of it. I've not read any case that says part of the document can be privileged in part. Now, I have read some cases that they've talked about, okay, if you have 5 documents, maybe one document would be sealed and the others are not, but there's never been something that, okay, part of this document it's a privileged document. It doesn't matter and it should not be disclosed. And again, I won't go into the third point because I think it would matter for the court to determine whether it's privileged or not first, and then whether we waived it. But I think the strongest argument here, I believe work product has not been, or sorry, attorney-client hasn't been waived, but either way, the standard is not the same between the two. It's almost always immune in the opinion work product. So I would just make sure it's clear that the standard is different. And I don't know what Mr. Quinnen needs to say that needs to be on the record that he can't say without like us having to seal the entire proceedings. I feel like we all know the court and the attorneys here involved know what it's pertaining to.
That's what we're gonna get to next. is-
Okay.
Okay, so this is the issue of privilege. And what I want to hear next is what it is that, given what you're arguing is privileged, what it is that you're asking, defense is asking to be sealed versus what state is asking me to be sealed. And then we'll hear from Miami Herald about their response.
So I
to
think the
that.
rule, Judge, does, if you go through the case, Lewis versus the Miami Herald, I think it does lay it out. And I think the biggest thing at the end is it says it has to be the least restrictive. Because
So for you guys, it's just essentially the one document.
it is, I think that protects it, as long as we are not discussing like the absolute details of what's included. We can talk around it in generalities, but I don't see, and I haven't heard Mr. Quinnen point to anything that makes me feel like we can't do it and just seal that one document.
Right, so Mr. Quinnen, before I get to the Miami Herald, why is it that you believe in, counsel for the Herald also suggested that you discuss this with them? Why do you believe that more things need to be sealed if I decide that document needs to be sealed?
Judge, as it is, just as a premise, in our response to the motion to compel the deposition of myself, I had to note at least a single quotation about paragraph 19. Our response, we had to, for lack of a better term, neuter it. So we couldn't go in through the dynamics and the aspects. We can only touch about the topics broadly as to privilege, waiver of privilege, why the waiver of privilege was perceived and assumed under those circumstances, and so on and so forth, just kind of broadly. As the court recalls in the litigation on the computer case, the pleadings on these topics were north of 20 pages. And this one obviously was 10 for several reasons, but we could not go into meat and potato issues. Again, as we've been tiptoeing around here and as admitted by Ms. Puglisi, at least 11 of the 20 items have been disclosed already publicly. And again, that buoys the point that voluntary disclosure is waiver, period. So, which by the way, it's their burden to show through evidence, which they also have not done. Counsel's assertion is not enough. And admission that that this was disclosed to a third party with consent, as we noted in our arguments, that's essentially it, is there was consent to tell the parents the status of the case. Because at the end of the day, as the court had noted, and the state relied on both internally and externally through advice and research, the parents' representation by Mr. Prieto and Ms. Puglisi was problematic to begin with. That doesn't preclude it. We've gone down the rabbit hole. That's a dead horse that I don't want to beat any further. But the point is that this has nothing to do with the parents' representation, and it only exclusively has to do with Ms. Clenney's representation. And it's completely unnecessary to have been disclosed in those circumstances. Again, the proffered excuse was that, oh, it's to let them know that we need money or we need this. That's not what that communication says. That's just telling them, hey, this is a status.
That again goes to my determination of whether
Yeah.
it's privileged. So I'm asking you why it is that you believe that you can't just reference the document in your pleadings or reference the bullet points in your pleadings without having to seal everything else.
I mean, a standard legal analysis is like in this case where X, Y happened. I cannot do that. That's just a practical aspect. So I have to make these arguments broadly about there wasn't privilege and privilege was waived, and I can't address why or how. I can only really say, et cetera. And as it is, again, referencing the court to page 7 of our response on the motion to depose, we narrowed it as explicitly as possible to the pertinent bullet point as to how the document even came up in our search. So, that's just the practical reality of being able to respond really neuters our ability to address it. Even if we just go ahead and say, you know what, the court relies on that and on what we've already put and is understanding our arguments around the parameters of that. Again, the first bullet point had to be disclosed. That was part of the problem with this timeline of the briefing, because the bullet point had to be referenced, absolutely could not go without being referenced on paragraph 19 of page 7 of our response. So we were okay with the records being sealed, hence why it was called an oppose, for the purposes of just getting this over with. And then however the court rules is however the court rules, and whatever's appropriate to be protected is protected, and whatever's not, that's perfectly fine. And the pleadings could be redacted and so on. But that I had to file a pleading by last week, Friday, in response, necessarily undercut the defendant's premise of their motion. So they did not have to file their motion to compel the day after they filed the motion to determine the confidentiality, is what I'm getting at. And by forcing that issue and forcing us to respond within the parameters, it necessarily undercut the premise of their sealing. So,
Any response?
I don't know what Mr. Quinnen wants to say, so it's hard for me to say that. I didn't think it was the least restrictive means. I really don't care so much whether it's sealed. I think the Miami Herald has something more to say about that, so I would leave it up to the court. I just felt it needs to be the least restrictive, and if you ask me, that's what it was.
Okay. All right, let me hear from, remind me again your name. I have
Yeah,
it here.
Scott Potts on behalf of Miami-Dade.
All right. Mr. Ponce, if you'll come forward to the microphone, please.
Yep.
Thank you.
Good afternoon, Your Honor. Scott Ponce from Holland and Knight on behalf of the Miami Herald. I think maybe the best place for me to start is to explain why I'm here. Obviously, anytime a motion comes across saying sealing criminal proceedings, my client's antenna goes up. But this one in particular, when we got the motion and read the motion, it seemed to me that there were discrete issues that were kind of being conflated and bouncing off each other. And when I emailed counsel for the parties, from vacation, no less. But when I emailed counsel for the parties to try to get an understanding, I got maybe even a little bit more confused. Although the judge I clerked for out of law school said, never say you're confused. But as I read it, what seemed to be my understanding of it was that there's a document, the defense contends it's privileged. The defense would like to make that an exhibit to an amended motion to disqualify. And it seemed like the issue of whether the document is privileged was going to be briefed in the disqualification papers also. And that seemed to not be the least restrictive means. And that was our concern, was that a motion to disqualify the state attorney's office needs to be done in public. This is a public institution, and the notion that that briefing might be sealed. It was problematic, especially problematic because it seemed like it didn't need to be. So our thought was, and I apologize if the papers were presumptuous, I don't think that they were, was that it made sense to determine in the first instance whether the document's privileged. Because if it's not,
I'm fine with the way that you outlined it.
All right. Well, thank you. Makes me feel better then. So the thought being that if the document is not privileged, then I don't know that there's any basis to seal any document to which it's attached. If you find the document is privileged, and again, I'm not attorney for the parties and I'm the stranger here and I know least about this than everyone in this room, but it's not clear to me why the document would need to be attached to anything. I mean, your honors reviewed it, your honor will determine it's privileged. Okay, the state saw it. Is there a basis to disqualify him on that basis? I don't, when we talk about least restrictive, I'm not sure why the document would have to be attached to something. But again, I think in the first instance, our concern was that there was suggestion in the papers, at least as I understood it, that the issue of whether the document was privileged was going to be briefed as part of the disqualification issue. And that the state's position was that if that were the case, then everything in the disqualification papers had to be sealed. And that felt like too much. So I'm happy to answer questions if you have any. I obviously can't speak to the privilege issues, nor do I want to. But that's kind of why I'm here and why this came up on our radar.
I tend to agree with you as to the way that you've outlined it, which is again why I've asked the state to explain to me why it is that I can't simply rule on this being privileged or unprivileged. And if I do rule that it's privileged, why it means that everything attached to it must also be sealed. And I kind of understand your argument that in order for you to make a full analysis, you believe that you have to reference the exact
Well, if there's,
exact portions of all the bullet points in the email that was sent. But I'll let you address what it is.
well, Judge, I mean, again, if the topic has been voluntarily disclosed and it's been voluntarily disclosed, whether it's
aside from
so-
whether or not I say that I do rule that it's privileged.
sure.
Why again?
Okay, so
Yeah,
then,
yeah, but say that I do.
okay, so then part of the analysis as it pertains to both the deposition and disqualification is what prejudice, if any, right? What prejudice, if any, exists from the inadvertent disclosure of this document, right? And the items contained within that document. Well, what prejudice, if any, exists to the defendant if her lawyer went on TV on July 8th of 2023 and said, we are doing that checklist?
Well, I don't think that that's the analysis that we're talking about for sealing.
No, oh, I'm sorry, I
We're talking
misunderstood.
about sealing right now.
Oh, Judge, again, the parameters is if the court assumes that it's privileged, then I can't discuss those materials openly, right? So if I can't say, they said they were going to hire blank, and they also said that on TV. You see what I'm saying? If the matter is sealed, I can't say they said this on TV. There is no prejudice.
Yes.
So here's where sorry to raise my hand, I was in third grade. Where I get confused a little bit here. Why would that be a discussion in the disqualification context?
Because if there's no prejudice, then there's no basis to disqualify.
Okay, I mean, it's just something I'm trying to understand, trying to be a partner
Yeah.
here and work through this, trying to understand why. If there's a determination made that the document's privileged and there's a determination made that the state saw it, I'm trying to understand why are we still talking about what's in the document or not and a disqualification issue if that matters.
Because again, if it's in a privileged document that was assuming it's privileged, because we don't take that position, and the basis of disqualification is they saw our strategy. It's like, but you also told everybody your strategy.
Why
Then-
should you be disqualified?
Yes.
Okay,
And
that's
that's-
helpful.
and
I'm just
that's the
trying to
problem.
understand.
And that's the problem is I cannot. I mean, again, if the court, listen, Google alerts are a beautiful thing. And so everything on this case that has come up from the defense telegraphing their case ad nauseum, it has come up. So again, half of that, from my original viewing of that, and again, I haven't parsed it recently, quite literally everything on there has been discussed in one respect or the other.
Like you could
So,
reference the bullet points without going into exactly what was in that document if I did rule that it was privileged, because obviously the balancing test here is issues that you guys are talking about are the public interest, and there is a right for the public to, view pretty much everything in this criminal case minus what might be privileged. So do you not think that there would be a way to craft your response if I did rule that it was privileged in a way that didn't actually quote anything in that? Because I feel like you could. You're
Yeah, Judge, I could theoretically say bullet point number 1 and then X, and bullet point number 2,
you could.
then X. But then X was already disclosed, outlines what bullet point number 2 is. So for example, I'm just going to use something that is in the public domain. Find Arthur Cupp, right, is the witness that is alleged to have seen everything else, right? Off the top of my head, I don't know if that's there, but you guys check on me. So let's say that's item number 2, find Arthur Cupp. So instead of saying, for example, item number 2 was disclosed to the media on this date at this time by Mr. Prieto when he said, we've located Arthur Cupp. How am I not disclosing item number 2 in making that argument?
Isn't it just you're not using his name?
I mean, I think that you could just say the witness was.
I mean, that's the point is how is it that I don't, in saying,
Well, listen, I don't think that I don't think that you need to worry about that. I think that you can make the argument if they've already disclosed it and if it's in the public domain already, you can reference whatever's in the public domain. And that issue is a defense issue.
yes, and that, I mean, that's, we've already articulated
Yeah.
that as much.
So
But that's what I'm saying is at this juncture, we've already gone as close as we can without going and making a deeper analysis on our motion to strike. So at this point, that's why I'm saying is it the defendant's attempt to maintain the records confidential is,
that's
is-
their issue
yeah.
as to whether or not they have already gone public with this information. But I do think that I could give you the parameters and you could easily, I think, draft a response knowing that I am able to see the document that wouldn't necessarily quote the document. Your reference of any public disclosures by the defense. I mean, feel free to reference that in whatever way you want to. It doesn't mean that you're the one putting that, quoting the document. I think
Judge,
that's on them.
I also think that if that becomes an issue, we can always go sidebar. Mr. Quinnen can lay forward, to the court, off the record. This is what I'd like to say, and I can't say it because of this. And then we can decide that, yes, okay, now there's a basis. We should seal it because you can't make that argument unless it's out.
And to agree with you, and I understand what you're saying now. I understand what you're saying about needing to show prejudice for all the elements that are in there, but I think that could be done without referencing the document. Okay. All right, now I lost my place. All right, Mr. Ponce, was there anything else that you wanted to say about that?
Unless you have questions.
All right, do you have anything that you want to say about your response to what Mr. Ponce had said? Because it seemed like you were essentially in agreement with the idea of going with the privilege first and then deciding what needed to be, whether anything needed to be sealed. But you said that there was one thing that you disagreed with, I feel like. No?
No, I don't think so. I
Okay.
think, it was only that if the court doesn't find it's privileged or finds that the defense waived it, I think that Mr. Ponce's argument is then, okay, then it should be disclosed. And our argument would be no, because it still is our mental impressions of the trial and there's no reason for the public to see it. And unlike what Mr. Quinnen is saying that, yes, the timing now is such that it's been disclosed. Some of these things have been disclosed. They're part of the public record, as you said. And we have discussed it in the media, but not all those things have. And that entire document is a privileged document, whether we have disclosed some of it or all, doesn't mean the whole thing should be disclosed. It's privileged. And so, and I can matter-of-factly say that not all of those items have been discussed in the media at all. So,
And I don't think that he's disagreeing with that, Mr. Quinnen.
I'm neither agreeing nor disagreeing, Judge. I can't.
You-
Again, I've on purpose recently avoided.
Okay, so yes, you've got your bullet points. All right, did you want to address anything else that Mr. Ponce had said or that the Miami Herald's concern is other than what you've already said about why you believe that there needs to be a broader
No, Judge, we were generally in agreement to maintaining that prophylactically. Our position was just that let's get this over with, and then after the fact, let's just get everything over with, and then after the fact.
Yeah, the idea was to get it over with before the new year. That's not gonna happen, but we're at least at this point. Okay, so I agree with the idea of ruling on the privilege first. And then deciding what needs to be. Actually, I mean, I can make the ruling, I can make both at the same time, based on what you guys have said, unless you have any other arguments that need to be made.
Judge, as it pertains to the waiver issue, I mean, I didn't go down the dynamics of that. Again, we have separate parties. And by separate parties, I mean, there's the state of Florida versus Courtney Clenney. There are witnesses within that case. Those witnesses can have representation at the time.
Sorry, and by both, I'm sorry, I didn't mean to cut you off. By both, I mean, I'm perfectly fine with ruling on the issue of privilege and what should be sealed, not that we're arguing the motion for.
No, it's on the privilege aspect, because again, there were certain aspects of it that go more towards that dynamic. But the essentially the broad stroke rule that the defense is trying to propose, where the parents are always agents of the defendant or have been always agents, is not one that's actually premised within the doctrines of attorney-client privilege or within the jurisprudence or within that rule. And specifically what I'd refer to is several different dynamics. First is the defendant has several jail calls with her parent. Does that mean that because her father administers her money, that I can't review the jail calls that she has with her parents? Logically, no, that doesn't follow. Notwithstanding that they're being told it's recorded or not. That's completely immaterial. Whether it's privileged or not, we should not be, even if it is recorded, I believe all jail calls are recorded even with counsel, but we don't get the ones with counsel. We explicitly are excised. They have to fill out paperwork and so on and so forth. So whether it's recorded or not is completely immaterial. And what's happening here is, for lack of a better term, because they keep using this term Team Courtney in this group chat. That was not evident in the group chat, first of all. But notwithstanding that, is just because you have a support group and everybody wants to know about what's going on and what's being done, it's incumbent on the counsels and their client to keep those lines of demarcation. For example, if Ms. Puglisi met with Ms. Clenney at the jail and said, we're going to do X, and then she picks up the phone and calls her mom and says, my lawyers are doing X, that privilege is waived. Ms. Hogan, I actually prosecuted another case where there was a similar circumstance where a person their representation was paid by a third party. I'm not going to go into the details because it's a little bit sensitive, but that third party had a complete barrier to the representation. Certainly, if you got a call and say, look, we need X more money because we have to hire an expert, I got to talk to my client about this, we should excise from there. And I explicitly use the example of when parents go in with a client to an interview and how the parents are supposed to be excluded from that interview with the client if they are to maintain any privilege, because if it gets discovered, we can't compel that testimony. Which, again, to the further privilege aspect, is the defense in December of 2022, when this email is being sent, knew A, the defendant was in communication with her mom, both written and oral, that they provided us photographs that Deborah Clenney took from her device on April 6th, 3 days after the homicide, purportedly showing bruising that was, again, purportedly caused by the victim. And so they knew that we had a basis to want Miss Deborah Clenney's phone and the contents of that. And we could have subpoenaed that, assuming she was within the jurisdiction for me to subpoena it. So what is on her phone? That is a textbook voluntary disclosure to third parties. That's what this document is. And again, calling it privilege, naming it privilege does not make it so. That document could have been called privilege, and it could have the scores for the Heat game and the stats. That doesn't make it so. And in this context, even if it was, which we don't necessarily disagree that it was when it was created. We disagree that it was opinion because it's just facts of what we're doing. But once it was put into an email and sent to the third parties, that was waived. And just as a perspective, the two exceptions there are for the purposes of the representation, and I forget the second one, you had it, It's for the purpose of the communication functioning, I believe. It's the second one that you mentioned.
Reasonably necessary for the transmission of the communication.
Correct. So it's reasonably necessary. So that would be Outlook or Google or whoever the servicer of that email is. We didn't intrude on Google, et cetera, or any of that stuff. We got it from Miss Deborah Clenney's iCloud. A, not knowing that there was a representation there. And then B, under the circumstances where that email was even open, it said update, not update privilege or privileged communication or any of that aspect. And B, the document did not reference Kim and Deborah Clenney's representation in any way. It was explicitly about Courtney and what they were doing about Courtney's case, which again is textbook, top to bottom, within four corners, voluntary disclosure under 90.507.
Judge, I'm just going to say that I think the state tends to join the two privileges together, and we have to make sure we keep them separate, attorney-client and opinion work product. Opinion, it doesn't have to be your opinions. It says mental impressions. Mental impressions are your thoughts. There's no question. These were my thoughts. And yes, it could have been the scores to the Heat game, but it was not. And it said privileged on it. And the prosecutor should have stopped when he saw a communication from attorneys to anybody and should have said, oh, I see an attachment that says privilege. He didn't stop at that point. He actually forwarded it to law enforcement, thereby making it a public record. So we have to, all his descriptions about it's not a jail call, which of course is recorded, and it doesn't have to be about finances. It doesn't have to say the magic words. This is, we need money from you. It says disclosures and furtherance of the rendition of legal services. These are points that help to justify what is being done in the case to represent their child. So I think it's very clear this is both attorney-client and work product, and that there was no waiver at any time, especially in the work product. It was meant to be kept from the eyes of our adversary.
And you don't believe that that was waived when you disclosed it to the parents?
In
as a third
opinion,
party?
no, because opinion, especially opinion work product, it talks about you can disclose to third parties. The test, the question is whether you reasonably could have known that it would get to the eyes of your adversary. So by giving, they're two totally different standards. So by us giving this information to the parents of what our opinion is in the case, the question is, could we have known that the prosecutors would have seen this email? And in order to prevent that, that's why you write privilege, so that you know that only the family, the people you're sending it to, are going to see it.
I have a slight disagreement because Ms. Puglisi keeps referencing adversary. So first, again, as witnesses, whether by us or by the defense, they would be subject to subpoena. And we could have taken sworn statements of them and possibly had discussed that, where we asked the question, have you discussed your daughter's case with the lawyers? So it wouldn't be a question about, did you discuss it as a witness and client of theirs? It would be, did you discuss it regarding her representation? And they might have been compelled to answer that. The second part is that the standard is not adversary. It's that the communication was made with the intent to keep it secret. Now, certainly it was meant to keep secret with Kim and Deborah Clenney. The problem is that as third parties to state of Florida versus Courtney Clenney, it's a voluntary disclosure. The very act of attaching it to the email and sending it to them constituted the waiver.
And Judge, and I don't totally understand what he's saying with respect to, there's no way they could have been compelled to answer that, but adversary is the state attorney's office in this case. That's who the adversary is to Courtney Clenney. And so clearly it was not meant to do that. And I can find the case, but it does talk about that.
I'll look at it.
Okay,
Yeah, my understanding is adversarial party.
okay.
Okay. All right, anything further before we stop for the day, and I give me time to read through everything and issue another written order?
No, Your Honor.
All right, so my order will be number one on the nature of privilege, whether I believe that it is privileged or not privileged, and two, if I believe that either it's privileged or not privileged, whether I believe that anything should be kept confidential, and if I do believe that it's confidential, what should be kept confidential? Okay, so it's going to be three parts. Everybody follow that?
Yes.
All right, and you're not Marvin, so I don't know how long to ask you for the transcript. What is your name? Alex. Okay, Alex, if I want a transcript, will I be able to get it in 10 days? Given the holidays, 10?
Yeah, just,
They should be there. I have copies. No, I have copies for orders there. If you look, there should, you guys, Ollie. No. All right, so let me reset it for 10 days for transcript, and then hopefully we'll get the transcript then, and then I'll give it a reset date with you. And if I get the current transcript, I'll give you all a copy of the transcript. Okay?
Thank you.
Judge, are we not then going to the motion to depose today? You're going to wait
not.
until that? Okay,
Because I agree, they should be separated.
okay.
1-3 is 10 days from now. That makes me feel bad, but we'll do 1-3 and yes. We're just gonna keep moving. Okay. All right, thank you. And then what was your name again, Alex? What was your last name? What is it?
Alejandro.
But what's your last name?
So, that's fine. No.
Did you want to set a date for,
Right now, I'm just gonna give the transcript and then, I mean, you can try to set a date, but let's just, everything takes
Mhm.
longer than I think it's gonna take, so.
so once we get the ruling, we should call your JA and ask
I think
for,
once we get the date for the ruling, you can probably come up with the date for the deposition.
okay.
Or the motion for deposition. Alejandro Silva, and are you also with laws? Okay, all right, thank you. All right, happy holidays, everybody.
Thank you. You as well, Judge.
Okay, so that's it. Judge has not ordered yet on whether the document will be confidential and what's going to happen in regards to using that document and the status of it being confidential or not confidential to because the prosecution has already seen it as to whether the case goes forward. So although it doesn't seem like a very important hearing, it actually was. But most important is going to be how the judge actually rules on it, which we're not going to hear until the beginning of the year. She'll get the transcripts. She's going to put her order in. But the Courtney Clenney case is not going to have much going on until the first week of January. We should have another hearing in January also in the middle of the month. But on that, everybody have a good night, and I'll be talking to you soon.